Law on Negotiable Instruments and Payment Transactions. October 24, 2005, Chapter 2, Checks. Section 1, The Drawing and Form of a Check. Section 2, Endorsement. Section 3, Avals. Section 4, Presentment and Payment. Section 5, Cross-checks and checks payable in account. Chapter 2, Checks. Section 1, The Drawing and Form of a Check. Article 3. A check is an unconditional order in writing, addressed to a banker and signed by the person giving the order, requiring the banker to pay a determinate sum of money to, or to the order of a specified person or to bearer. It must be payable at sight and conform to all requirements provided by this chapter. Article 4. A check is a payment instrument. It may be written in Khmer or any other language and must contain the term check inserted in the body of the instrument and expressed in the language employed in drawing up the instrument. An unconditional order to pay a determinate sum of money. The name of the banker who is to pay, drawee. A statement of the place where payment is to be made. A statement of the date when and the place where the check is drawn. The signature of the person who gives the order on the check, drawer. Article 5. An instrument in which any of the requirements mentioned in the preceding article is wanting is invalid as a check, except in the cases specified in the following paragraphs. 1. In the absence of special mention, the place specified beside the name of the drawee is deemed to be the place of payment. If several places are named beside the name of the drawee, the check is payable at the first place named. 2. In the absence of these statements, and of any other indication, the check is payable at the place where the drawee has his principal establishment. 3. A check which does not specify the place at which it was drawn is deemed to have been drawn in the place specified beside the name of the drawer. Article 6. A check must be drawn on a banker holding funds at the disposal of the drawer and in conformity with an agreement express or implied, whereby the drawer is entitled to dispose of those funds by check. Nevertheless, if these provisions are not complied with, the instrument is still valid as a check. Article 7. 1. A check cannot be accepted. A statement of acceptance on a check shall be disregarded. 2. A check does not operate as an assignment of funds in the hands of the drawee available for payment thereof, and the drawee of a check is not liable to the holder. Article 8. 1. A check may be made payable. A. To a specified person with or without the express clause to order, or B. To a specified person, with the words not to order or equivalent words, or C. To bearer. 2. A check made payable to a specified person with the words or to bearer, or any equivalent words, is deemed to be a check to bearer. 3. A check which does not specify the payee is deemed to be a check to bearer. Article 9. 1. A check may be drawn to the drawer's own order. 2. A check may be drawn for account of a third person. 3. A check may not be drawn on the drawer himself unless it is drawn by one establishment on another establishment belonging to the same drawer. Article 10. Any stipulation concerning interest which may be embodied in the check shall be disregarded. Article 11. A check may be payable at the domicile of a third person either in the locality where the drawee has his domicile or in another locality, provided that such third person is a banker. Article 12. 1. Where the sum payable by a check is expressed in words and also in figures, and there is any discrepancy, the sum denoted by the words is the amount payable. 2. Where the sum payable by a check is expressed more than once in words or more than once in figures, and there is any discrepancy, the smaller sum is the sum payable. Article 13. If a check bears signatures of persons incapable of binding themselves by a check, or forged signatures, or signatures of fictitious persons, or signatures which for any other reason cannot bind the persons who signed the check or on whose behalf it was signed, The obligations of the other persons who have signed it are none the less valid. Article 14. Whoever puts his signature on a check as representing a person for whom he had no power to act is bound himself as a party to the check and, if he pays, has the same rights as the person for whom he purported to act. The same rule applies to a representative who has exceeded his powers. Article 15. The drawer guarantees payment. Any stipulation by which the drawer releases himself from this guarantee shall be disregarded. Article 16. If a check which was incomplete when issued has been completed otherwise than in accordance with the agreements entered into, the non-observance of such agreements may not be set up against the holder unless he has acquired the check in bad faith or, in acquiring it, has been guilty of gross negligence. Section 2. Endorsement. Article 17. 1. A check made payable to a specified person, with or without the express clause to order, may be transferred by means of endorsement. 2. A check made payable to a specified person, in which the words "not to order" or any equivalent expression have been inserted, can only be transferred according to the form and with the effects of an ordinary assignment. 3. A check may be endorsed even to the drawer, or to any other party, to the check. These persons may re-endorse the check. Article 18. 1. An endorsement must be unconditional. Any condition to which it is made subject shall be disregarded. 2. A partial endorsement is null and void. 3. An endorsement by the drawee is also null and void. 4. An endorsement to bearer is equivalent to an endorsement in blank. 5. An endorsement to the drawee has the effect only of a receipt, except in the case where the drawee has several establishments and the endorsement is made in favor of an establishment other than that on which the check has been drawn. Article 19. 1. An endorsement must be written on the back of the check or on a slip affixed thereto, allonge. It must be signed by the endorser. 2. The endorsement may leave the beneficiary unspecified or may consist simply of the signature of the endorser. Endorsement in blank. Article 20. 1. An endorsement transfers all the rights arising out of a check. 2. If the endorsement is in blank, the holder may a. Fill up the blank either with his own name or with the name of some other person. b. Re-endorse the check in blank or to some other person. c. Transfer the check to a third person without filling up the blank and without endorsing it. Article 21. 1. In the absence of any contrary stipulation, the endorser guarantees payment. 2. He may prohibit any further endorsement. In this case, he gives no guarantee to the persons to whom the check is subsequently endorsed. Article 22. The possessor of an endorsable check is deemed to be the lawful holder if he establishes his title to the check through an uninterrupted series of endorsements, even if the last endorsement is in blank. In this connection, cancelled endorsements shall be disregarded. When an endorsement in blank is followed by another endorsement, the person who signed this last endorsement is deemed to have acquired the check by the endorsement in blank. Article 23. An endorsement on a check to bearer renders the endorser liable in accordance with the provisions governing the right of recourse. However, it does not convert the instrument into a check to order. Article 24. Where a person has, in any manner whatsoever, been dispossessed of a check, whether it is a check to bearer or an endorsable check to which the holder establishes his right in the manner mentioned in Article 22, the holder into whose possession the check has come is not bound to give up the check unless he has acquired it in bad faith or unless in acquiring it he has been guilty of gross negligence. Article 25. 1. Persons sued on a check cannot set up against the holder defenses founded on their personal relations with the drawer or with previous holders, unless the holder in acquiring the check has knowingly acted to the detriment of the debtor. 2. Paragraph 1 does not apply to a check made payable to a specified person, in which the words "not to order" or any other equivalent expression have been inserted. Article 26. 1. When an endorsement contains the statement value in collection, valeur en recouvrement, for collection, pour encasement, by procuration, par procuration, or any other phrase implying a simple mandate, the holder may exercise all rights arising out of the check. But he can re-endorse it only in his capacity as agent. 2. In this case, the parties liable can only set up against the holder defenses, which could be set up against the endorser. 3. The mandate contained in an endorsement by procuration does not terminate by reason of the death of the party giving the mandate or by reason of his becoming legally incapable. Article 27. 1. An endorsement after protest or after an equivalent declaration or after the expiration of the limit of time for presentment. I operates only as an ordinary assignment, and 2. Does not operate to give rights under Articles 22, 24, and 25. 2. Failing proof to the contrary, an undated endorsement is deemed to have been placed on the check prior to the protest or equivalent declaration or prior to the expiration of the limit of time referred to in the preceding paragraph. Section 3, Avals. Article 28. 1. Payment of a check may be guaranteed by an aval as to the whole or part of its amount. 2. This guarantee may be given by a third person other than the drawee, or even by a person who has signed the check. Article 29. 1. An aval may be given either on the check itself or on an allonge. 2. It is expressed by the words good as aval, or by any other equivalent formula. It is signed by the giver of the aval. 3. It is deemed to be constituted by the mere signature of the giver of the aval, placed on the face of the check. 4. An aval must specify for whose account it is given. In default of this, it is deemed to be given for the drawer. Article 30. 1. The giver of an aval is bound in the same manner as the person for whom he has become guarantor. 2. His undertaking is valid even when the liability which he has guaranteed is inoperative for any reason other than defect of form. 3. He has, when he pays the check, the rights arising out of the check against the person guaranteed and against those who are liable to the latter on the check. Section 4, Presentment and Payment. Article 31. 1. A check is payable at sight. Any contrary stipulation shall be disregarded. 2. A check presented for payment before the date stated as the date of issue is payable on the day of presentment. Article 32. A check must be presented for payment within 6 months of its date. Article 33. Where a check is drawn in one place and is payable in another having a different calendar, the day of issue shall be construed as being the corresponding day of the calendar of the place of payment. Article 34. The presentment of a check either at or through a clearinghouse, or electronically, as provided by agreement or regulations issued by the National Bank of Cambodia, is an effective presentment for payment. Article 35. 1. Payment on a check may be countermanded without prejudice to the rights of the holder. 2. If payment on a check has not been countermanded, the drawee may pay it even after the expiration of the time limit for presentment. Article 36. Neither the death of the drawer nor his incapacity taking place after the issue of the check shall have any effect as regards the check. Article 37. 1. The drawee who pays a check may require that it shall be given up to him receipted by the holder. 2. When there is insufficient cover in the drawer's account, the holder may not refuse partial payment. 3. In case of partial payment, the drawee may require that the partial payment shall be mentioned on the check and that a receipt shall be given to him. Article 38. The drawee who pays an endorsable check is bound to verify the regularity of the series of endorsements, but not the signature of the endorsers. Article 39. 1. A check is deemed to be an authorization given to the drawee to pay in the currency of the account on which it is drawn. 2. When a check is drawn payable in a currency which is not that of the account, the sum payable may be paid by the drawee in the currency of the account according to its value on the date of payment. 3. If a check drawn payable in a currency which is not that of the place of payment has not been paid on presentment, the holder may at his option demand from a party liable that payment of the amount of the check be made in the currency of the place of payment according to the rate on the day of presentment or on the day of payment. 4. The usage of the place of payment shall be applied in determining the value of foreign currency. Nevertheless, the drawer may stipulate that the sum payable shall be calculated according to a rate expressed in the check. 5. Notwithstanding paragraph 3, a check either drawn payable in a currency which is widely accepted in Cambodia, or in which the drawer has stipulated that payment must be made in a certain specified foreign currency, may be enforced by the holder against any party liable in the stated currency. 6. If the amount of the check is specified in a currency having the same denomination, but a different value in the country of payment and the country of issue or any other country, unless specifically indicated otherwise, where the currency is not that of the account, reference in the check is deemed to be made to the currency of the country of payment. Where the currency of the country of payment does not have the same denomination, reference is deemed to be made to a currency which is widely accepted in the place of payment. Section 5. Cross checks and checks payable in account. Article 40. 1. The drawer or holder of a check may cross it with the effect stated in the next article hereof. 2. A crossing takes the form of two parallel lines drawn on the face of the check. The crossing may be general or special. 3. The crossing is general if it consists of the two lines only or if between the lines the term banker or some equivalent is inserted. It is special if the name of a banker is written between the lines. 4. A general crossing may be converted into a special crossing, but a special crossing may not be converted into a general crossing. 5. The alteration either of a crossing or of the name of the banker shall be regarded as not having taken place. Article 41. 1. A check which is crossed generally can be paid by the drawee only to a banker or to a customer of the drawee. 2. A check which is crossed specially can be paid by the drawee only to the named banker, or if the latter is the drawee, to his customer. Nevertheless, the named banker may procure the check to be collected by another banker. 3. A banker may not acquire a crossed check except from one of his customers or from another banker. He may not collect it for the account of other persons than the foregoing. 4. A check bearing several special crossings may not be paid by the drawee except in a case where there are two crossings, one of which is for collection through a clearing house. 5. The drawee or banker who fails to observe the above provisions is liable for resulting damage up to the amount of the check. Article 42. 1. The drawer or the holder of a check may forbid its payment in cash by writing transversely across the face of the check the words payable in account, au porter en compte, or a similar expression. 2. In such a case, the check can only be settled by the drawee by means of book entry such as credit in account, transfer from one account to another, set off or clearing house settlement. Settlement by book entry is equivalent to payment. 3. Any obliteration of the words payable in account shall be deemed not to have taken place. 4. The drawee who does not observe the foregoing provisions is liable for resulting damage up to the amount of the check.